The High Court will rule on the legality of the Affordable Housing Act on 22nd of October 2024. In their submissions to the three-judge bench, the defendants argued that affordable housing program would reverse the proliferation of slums that currently number 1,422 slums and costly land prices that Kenya ranks highly in Sub Saharan Africa. And as Ruth Wamboi reports, on the second and last day of the hearing, the defendants also argued that the high cost of rent forks about 60% of Kenyans' incomes.
Senior counsel Githu Muigai and Mahat Somani on Thursday led the defense team in vouching for the government's affordable housing program.
It leads to health issue in sanitation. It leads to insecurity problem. So our contribution are supposed to arrest that social problem. If this is not done, in another 10 years, likely most of us will be living in these slums. Or these slums will have encroached to wherever everyone is living.
They urged the court to look at the broader picture to appreciate the full benefits of the affordable housing for the larger Kenyan population.
Parliament having spoken to the Affordable Housing Act, I believe the petitioners would be barred from alleging otherwise in terms of its constitutionality and validity.
They told the Justice Olga-led bench that the program will also enhance social amenities in residences.
Who live in slums, some who do not have houses, and therefore to ensure that their rights to dignity under Article 28 of the Constitution is guaranteed and protected.
In their rebuttal, the petitioners faulted Parliament for assuming that the priority of all the 55 million Kenyans was housing.
To do away with those functions, either they seek a transfer of the functions or they amend the Constitution. This is the supreme law. Any other explanation is a waste of time.
They just remain like that, illegal. We submit that the act that is under challenge, it is a process, it is a product of a poisonous tree.
They also urged the bench to consider the myriad of unconstitutional clauses in the act vis-a-vis the government's civic responsibility.
I submit that you cannot repeal an unconstitutional act because it is not law.
And I pray that this honorable court, my lord, saves Kenyans with a catastrophe which likes to happen.
Justices Olga Sewe, John Chigiti and Josephine Mongare have retreated to draft their judgment and deliver it in 3 weeks' time.
We propose to deliver the judgment on the 22nd of October.
6 petitions had been filed challenging the various provisions of the Affordable Housing Act and were consolidated before they were heard by the bench, constituted by Chief Justice Martha Koome. Day 2, and the government has insisted that it's doing its obligation to arrest the slum menace in the country, even as the petitioners during rebuttal contested the move, saying the act has not pronounced itself on whether the right to pay is the right to own the property. All eyes are now set on the three-judge bench. Ruth Wamboi reporting from Milimani's High Court.